Namaskar and good evening to everyone. Thank you Ajay Bhai, thank you Vikram Bhai, and thank you Manthan for having me this evening. Manthan is one of the most vibrant platforms to discuss and debate issues affecting our lives. I congratulate Ajay Bhai, Vikram Bhai and their team and all of you who solidly are connected to it in your endeavor. Manthan Dialogues makes me feel that democracy is safe. I feel privileged to be here this evening and thank Manthan and all for being here to listen to my thoughts on the Constitution, rule of law, and governance during COVID-19. Let me begin this talk with a little caveat. Satyam bruyat, priyam bruyat, na bruyat, satyam apriyat. Be truthful and sweet in speech, but do not speak out unpleasant truth. I must begin with an apology that I intend to speak unpleasant truth this evening, and I seek your forgiveness in that. Let me begin the rationale for this discussion. When we decided to have this topic, we really were very serious about the state of the country. And the rationale for this topic and today's debate has been most brilliantly expressed by then President of Kosovo, a small nation, Mr. Atifet Jahagiajo. He said, and I quote, and these are amazing words, and I'm surprised nobody in India has ever spoken these words. I quote him, "Democracy must be built through open societies that share information. When there is information, there is enlightenment. Where there is debate, there are solutions. When there is no sharing of power, when there is no sharing of power, no rule of law, no accountability, there is abuse, corruption, subjugation, and indignation." Now that's really the state that we perhaps may be today. Today's India is reeling under lack of information and at times disinformation. There are hardly any debates on the issues of fundamental importance. Nation wants to debate Sushant Singh Rajput's unfortunate death, we are told, or at best, arrival of 5 Rafale fighter jets from France. We are inundated with every detail on the life of late Mr. Sushant Singh Rajput and his friends and servants. We are told the minute path of the Rafale jets arriving into India. But we are not told about the sufferings of the masses, the large-scale unemployment, the miseries of the farmers, the non-functioning of the parliament and its committees, the half-baked functioning of the judiciary, depriving thousands from much-awaited justice. In passing, yes, but not in detail. Certainly not required in information and definitely not in debates. Has India been informed why between January 23rd, when China declared COVID-19 as a pandemic, and mind you, the World Health Organization also gave sufficient warning by 31st of January, no effective steps were taken to prevent this curse on humanity called COVID-19. Have we been informed why as late as February 24, over 1 lakh people gathered in Ahmedabad to watch the Trump saga? And mind you, on 4th of February 2020, if I recollect correctly, Government of India through Ministry of Home Affairs had issued a strong advisory against public gatherings. Have we been informed what was the amount of effect, or what was the scale of the effect of COVID spread due to these lapses? Have we been informed on what basis lockdown was declared on March 23rd, giving nation of 130 crore people just 6 hours notice, combined with imposition of section 144 notifications across the cities, stoppage of trains and buses, leaving hundreds of millions stranded at unwanted places. Where was expert advice sought by the government? If yes, was it followed? Were these issues affecting our lives and livelihood debated at all? The bitter truth is that they have not been. But we debated Nizamuddin Markaz for weeks, resulting in criminalization of sickness, FIRs and arrests of hundreds, if not thousands, unfortunate, people belonging to minority community who were stranded due to sudden and severe lockdown. We demonized the entire community of 150 million citizens belonging to this country. Was this not anti-national to create hatred amongst us? Yet no action has been taken against the perpetrators of false and vicious campaign. Last week, fortunately, and hats off to the division bench of the Bombay High Court, Aurangabad bench, it has struck down some of the FIRs against certain foreign Muslim gentlemen who had arrived from Indonesia. And while doing so, the High Court has strongly criticized the approach of the authorities in arresting them, in taking action against them, and said that COVID-19 sickness could not have been criminalized in this fashion. The High Court has particularly spoken about the role played by the media in spreading hatred in that. And I therefore feel really relieved that the High Court has gone into it and really taken this very seriously. Could India have protected itself better against the effects of COVID-19 if right steps were taken by the end of January? Maybe, maybe not. Critics may say it is all right to talk in hindsight. No, I say it speaks of vision. Vision on the part of those who are entrusted by us, we the people, to govern and not to misgovern. Current pandemic situation is so grave for the nation and its people that it demands sharing of power between those in governance and those governed. What we need today very seriously is participatory democracy. If that is missing, and it does appear to be missing, then there will be no rule of law, no accountability, and it will result in abuse, corruption, subjugation, and indignation. We must prevent this. There is no denying that the Prime Minister of India means well, but the absolute discretion with him does not augur well for our democracy. Demonetization and lockdown are two examples which remind us of the limitations of even the most popular leader. Severe damage to the economy, its growth, loss of production and services, reduced exports, and most of all, loss of millions of jobs are direct results of the abrupt political decisions taken by him. Dr. Ambedkar had forewarned us, saying, not to lay, and I quote him, not to lay our liberties at the feet of even a great man, or to trust him with powers which enable him to subvert the institutions. What he meant, the democratic institutions, to maintain democracy. So in a situation like this, Constitution plays an important part more than any other times. Constitution is a contract amongst us, the citizens, for the conduct of our nation. It is a fundamental document which defines power and position of the three organs of the state, the executive, the legislature, and the judiciary. It also defines the powers of the executive and legislature as against the citizens. For example, the fundamental rights. The purpose of Constitution is not merely to create the organs of the state, but to limit their authority. If no limitation was imposed, Dr. Ambedkar said on 17 September 1949 in the Constituent Assembly, and I quote, there will be complete tyranny and complete oppression. The legislature may be free to frame any law. The executive may be free to take any decision. And the Supreme Court may be free to give any interpretation of the law. It would result in utter chaos. Are we in chaos? See, this is something each of us have to ponder and answer for ourselves. It is said, power and knowledge do not go together. Oftentimes, they are disassociated. Constitution may give power, but not wisdom to exercise that power. That depends on what is broadly understood as constitutional morality, which means paramount reverence for all forms of the Constitution. It is also described as an emotion to be created amongst leaders and through them amongst the masses. Diffusion of this morality, respect for the Constitution, is the indispensable condition of governance, at once free and peaceable. Dr. Ambedkar had declared, democracy in India is only the top dressing of an Indian soil, which essentially is undemocratic. Aristotle had once said, stability of a constitution is the education of citizens in the spirit of the constitution. Albert Einstein put it even more pithily when he said, the strength of the constitution lies in the determination of each citizen to defend it. Can we say that today we are having a functional democracy with legislatures shut and judiciary virtually shut since March 23rd? Has this led to tyranny in operation, as predicted by Dr. Ambedkar, is for each of us to realize. Parliament has not been able to debate much, less challenge the government for its decision taken since March 23rd and imposed on 130 crore people. Judiciary has virtually, if not completely, refused to intervene on specious ground that in policy matters it will not intervene. Executive has been left free to take any decision without any limitation, contrary to the spirit of the Constitution. Rule of law is the basic structure of the Constitution, as has been held by Supreme Court time and again. Theory that king can do no wrong was demolished almost 200 years ago in England when Chief Justice Edward Coke held that king should be under the God and the law. Be you ever so high, the law is above you, is the principle that governs every democracy. Rule of law means supremacy of law and equality before the law. Professor Dicey, one of the most leading exponents of constitution and rule of law, said, and I quote him, with us, every official from the prime minister down to the constable is under the same responsibility of every act done without legal justification as any other citizen. In a decent society, and I believe we are, it is unthinkable that government or any officer of the government possesses arbitrary power over the person or the interest of an individual, and that effective judicial remedies are more important than abstract constitutional declarations in securing right of the individual against violations of the state. Now, this is very important. You can't have abstract theories and not effective judicial remedies. This is the time when effective judicial remedies are a condition precedent for every citizen of the country. Justice H.R. Khanna, one of the greatest, perhaps the greatest judge post-independence in India, during emergency in ADM Jabalpur's case, the famous or rather infamous ADM Jabalpur case, in his powerful dissent said, rule of law is the antithesis of arbitrariness. In all civilized societies, it has been regarded as the mark of free society. Majority of the judges didn't agree with Justice Khanna, and this included Senior Justice Chandrachud, Justice Bhagwati, who has been considered to be one of the finest judges of the country. And the majority in that judgment said that fundamental rights need not be enforced during emergency, and that the Supreme Court need not give citizens the benefit of fundamental rights. Now, this is one of the most disgraceful judgments in the history of the Supreme Court. And both Justice Chandrachud and Justice Bhagwati, before their deaths, apologized to the nation for the judgment. But what is important is that at a time in emergency, when we needed the judges, when we needed our Supreme Court, it failed us. It was only Justice Khanna who stood tall. We are not in emergency as at the present, as it is known in the Constitution. Yet we saw from March 23rd, for months on, how millions of Indians who happen to be migrant workers, keeping the wheels of the economy moving, were deprived of their basic human rights and fundamental rights under the Constitution. 6 hours to lockdown proved to be a disaster for them and the nation. Their plight brought tears into the eyes of sensitive Indians, but the government did not budge. They did not restart trains and buses. They did not provide food and shelter on the way. Instead, governments even closed borders on the states, forcing already crucified human beings to stay under sun and rain. They were even sprayed with pesticides to wash them of their sins of wanting to go home. They lost jobs, their livelihood, their homes in shanties, and their belongings. But more than that, they suffered pain and humiliation. And believe you me, Supreme Court has time and again said that right to life under Article 21 of the Constitution of India includes right to live with dignity. We deprived them of their dignity. Millions and millions of Indians. Did the government not envision this problem before declaring a sudden lockdown? Did it not know that there are hundreds of millions of Indians living far away from their homes? What was the government thinking? We will never know because we have no information as to how this infamous decision to declare the lockdown was taken. We cannot debate it as debates on such issues are unwelcome in this country. Disaster Management Act 2005 is a complete code to deal with a situation like COVID-19. It provides for one disaster management authority at the center and state and district levels. It provides for making a national disaster plan, a comprehensive plan to decide as to what measures should be taken to prevent and to ameliorate the difficulties of people. It provides for funding by the central government and state government into National Disaster Response Fund and State Disaster Response Fund. These funds are then to be utilized to help those who have suffered, including giving them financial assistance for loss of livelihood. This is very important. And it further provides that all contributions that citizens make or the institutions make to fight the disaster, to help those suffering from disaster, is automatically credited into National Disaster Response Fund. This is very important by virtue of Section 46 of that Act. These funds are to be utilized as provided in the statute, and the utilization is subject to scrutiny and audit by Controller of and Auditor General of India, a constitutional authority. Disaster under this Act is extremely widely defined, and it includes a biological challenge like COVID-19. Now, this is very crucial. This Act came in 2005. The Act was singularly ignored by a successive Congress government which had brought the Act. And I mean, fortunately for the country, it was none other than Prashant Bhushan and his NGO who moved the Supreme Court to ensure that this Act is enforced. It is given, life. The Supreme Court, by a beautiful judgment in 2016, I think Justice Madan Lokur, speaking for the Supreme Court, said that this Act is absolutely necessary because unless we implement the Act, unless we have proper national plans to fight disasters of all kinds, whether it is floods, whether it is drought, whether it is locust, whether it is COVID-19, every kind of a disaster is to be tackled on a comprehensive, systematic, scientific basis. So the Supreme Court set into motion this Act in 2016. And for the first time, the government came out with a national plan in 2019. Now, this is important because 2019 National Disaster Plan has few lines on biological disaster like COVID-19. The Act contemplates that such plans must be made annually. We are now 5 months down into the COVID-19 situation. And till today, the government has not brought a comprehensive national disaster plan to fight COVID-19. Now, this is something which is absolutely shocking, because if you don't have a plan, you are doing a great disservice to the country. Not only you are not following the law, the rule of law, the parliament's own legislation, but you are functioning in an extremely ad hoc manner to deal with this situation. Now we are seeing that ad hocism. More than 5,000 different orders, notifications, and advisories have been issued by the government of India alone, besides thousands more by the state governments, to deal with this situation, so that the citizens can never know what the government is doing. Which citizen today has time to go through these thousands of notifications, orders and advisories to know what the government is planning to do, what it is doing and what it is not doing? More important, the citizens do not know what rights they have in this situation. Whether they have a right to get financial assistance for loss of livelihood, whether they have right to get any kind of compensation for the kind of suffering and humiliation that these millions of migrant workers did? The answer is no. We have no idea as to what the rights of the citizens are in a situation like this. Now, this is very important. This is called rule of law. And there is singular absence of basic rule of law today in this extraordinary situation facing humanity. This country, let us pray, will never see a challenge like COVID-19. But today, to meet this challenge, I must say that government is thoroughly ill-prepared. But more than that, the nation is thoroughly ill-prepared to debate it. Not one leader of opposition has asked this question. Not media, no section of media has debated that why is it that Mr. Prime Minister, your government is not bringing a national disaster plan to fight COVID-19. Now, this is something which is very troublesome, that if we do not debate it, then I think, what answer can we give to our constitutional forefathers, to our freedom fighters who laid their lives to give us this democracy? Thousands of men, women, and children died. Our democracy is founded on rivers of blood. Our constitution is written in blood. We are doing a great disservice to their sacrifices by not even asking question from our government that why is it that you are not following the law or letter of the law. Now, this is something which is very, very troublesome to me. This was a time, I must also say one thing, that after the lockdown, and this is important, lockdown, as we all know, has caused immense economic damage, almost irreversible damage to the country. Not only millions have lost jobs, but I think thousands and thousands of businesses are likely to go out of business. And once the moratorium expires on 31st of August, we don't even know what is going to be the situation with small and medium businesses, or even large businesses in various sectors like real estate, textiles, jewelry making, all kinds of businesses, service sectors, hotel industry, hospitality industry. Everybody is, today reeling under severe impact of the lockdown. Now, what is important is that did lockdown serve any purpose? Is anybody asking a question that after 24th of March 2020, the spread of COVID-19 has increased in this country several thousand times? Now, what was therefore the purpose of bringing a lockdown if you could not contain the spread of COVID-19, which was the basic aim of the lockdown? Which means that lockdown was not only ill-conceived, but it was ill-executed and it was ill-thought. And it has definitely failed to bring the results which country really deserve. Countries like South Korea, countries like Taiwan, countries like New Zealand have fared much better than us in fighting COVID-19, because what they did was remarkable, that they stopped all foreigners from entering their countries from 1st of February 2020. While we were welcoming President Trump and thousands of NRIs, Gujarati NRIs in Ahmedabad, who wanted to come and shake hands or dance to the tunes of Mr. Trump's, great lecture, every one of the responsible countries stopped entry of foreigners into their country and put all returning citizens of their countries to 14 days absolute quarantine. Now, that helped contain to a great extent. And as a result of that, countries have gone back on their feet. Even China, from where the virus has come, is back on its feet. China's GDP has increased in last quarter. Our GDP has fallen, God knows by what percent, but most experts believe by at least 20 to 30%. Now, can a poor nation of 130 crore people, where there is large scale poverty, almost half of the population living below poverty line, can it afford this kind of ill thought, ill conceived and ill executed executive actions which are completely unchecked by parliament and judiciary altogether? Let me tell you something shocking. Demonetization. Now, every economist has said in the world that demonetization was a wrong move, except the government, which does not want to admit. But what is sad is, when demonetization was challenged before the Supreme Court, it refused to intervene. But more than that, it has not heard that matter till today. Now, this is the state of affairs in the country, where every constitutional body is virtually ceding its turf to the executive and mainly to the Honorable Prime Minister. He has a towering personality. And that is why Dr. Ambedkar had warned way back during the Constituent Assembly debate. He said, Bhakti is not good in public life, in politics. And he said, Bhakti in politics, mind you, in 1949, Bhakti in politics in India is most prevalent in the world. He said, Bhakti is a good path to salvation of the soul. But Bhakti in politics is a sure path to degradation and ultimate dictatorship. Now, this is the warning that one of the greatest Indians ever to be born has given us from 1949. Perhaps he had Gandhiji and Nehru in mind, because he didn't get along with them. And he saw that people worshipped Gandhi and Nehru and Sardar Patel, like God, like demigods. Today we are in a situation where, because of the towering personality of the Prime Minister and complete absence of any kind of opposition, there is no other leader parallel to him in public life today who can stand up and even debate with him. Now, as a result of that, we are willing to accept anything and everything that is given to us by the executive, and judiciary just sits silently. Now, this is something which is very troublesome, because the very basic principle of the Constitution is that every constitutional authority will enforce the Constitution. The judges are under a constitutional oath, and their constitutional oath says that I will decide without fear or favor. Now, why should judges therefore give? In fact, I'll tell you something shocking. When petitions challenging Article 370's removal came up before the Supreme Court, and large number of persons were arrested in preventive detention in Jammu and Kashmir, including President of the Bar Association, and petitions were brought before the Supreme Court. Then Chief Justice Gogoi, I don't know whether he could be considered to be Chief Justice or not, but he virtually said, oh, let us give executive some time. Now, it is impossible that the judiciary would ever make such a statement and defer preventive detention petitions. The law is that if a preventive detention is brought, a habeas corpus petition before a court, the court will put aside every other matter and hear the habeas corpus petition first. That's how the jurisprudence was developed, because liberty of a citizen is extremely important. And the court cannot defer that to the executive judgment or the executive discretion, which it did. Now, it's a very sad commentary on the functioning of the Supreme Court that this is happening again and again. It's not, everybody loves the Supreme Court. We all respect the Supreme Court. I do, and I'm sure citizens do. It's one of the most revered institutions in the country. But its failures in recent times have been abject, as it was in ADM Jabalpur. And these failures have caused immense pain and suffering to the citizens of this country. The scars which are inflicted on account of these failures by constitutional bodies are absolutely impossible to feel. Now, take, for example, the Prime Minister Care Fund. Now, as I said, that under the Disaster Management Act, Section 46 says that every contribution made by an individual or an institution to fight disaster must automatically get credited into National Disaster Response Fund. Now, to overcome, this, or to get out of this, the government of Prime Minister Modi has refused to activate NDRF to fight COVID-19. Now imagine that NDRF is not pressed into service to fight COVID-19, which is the greatest challenge affecting the country. And I will tell you something more shocking, that 1 month after COVID came, there was serious challenge of locusts in states like Rajasthan and Gujarat. The government issued notification activating NDRF and State Disaster Response Fund both to fight locusts. Now, small issue like locust, government felt it necessary to press NDRF so that the National Disaster Response Fund is made available to fight locust menace. But it thinks that to fight COVID-19, it's not necessary. Now, why did government do that? Because side by side, the government had created PM Care Fund. PM Care Fund is created by the Prime Minister's office. We saw advertisements by government all across the country inviting people to contribute. I have myself contributed substantially to that fund. At that stage, nobody knew what's going to be its composition, its character. Now it has become it's a private trust, which is where trustees are Honorable Prime Minister and few ministers. It is managed by government officers, but it is not being subject to CAG audit. It is to be audited by a private auditor. Now, to get out of, and its funds are not automatically credited to NDRF. Now, therefore, this trust can, use its discretion, as it has, some newspaper reports have come that it gave some money for ventilator production, etc., which have failed. We have just seen a report yesterday that 2 hospitals in Bihar are going to be given the funds. It's completely discretionary, and that discretion is bound to be misused. And it is unchecked. CAG is a constitutional body. Its audit is subject to my Right to Information Act. A private auditor is not subject to that. Now, this is something which is extraordinarily, I would say, disappointing, because Prime Minister is an honest man. Nobody can accuse Prime Minister of being corrupt. But he is ill-advised by his advisors, who have now, created this monstrous of a fund called PM Care Fund, in which presently, as people talk about, more than 10,000 crores have been collected. And therefore, this is a clear example of how this kind of, I would say, reluctance to follow the law takes place. Now, Parliament has a committee, I forget which committee it was, but one of the parliamentary committees wanted to discuss the PM Care Fund. And the committee chairman said flatly, who belongs to the ruling party, that we will not even discuss it. Public Accounts Committee. Yes, it was Public Accounts Committee. Now just imagine, you look at today United Kingdom, look at even United States of America. The Congress is in session, the Senate is in session in America. The Parliament is in session in England. And the Prime Minister and the Presidents respectively appear and answer there. Here, because Parliament is not functioning, the Prime Minister doesn't have to answer anybody. And we, the citizens, can only hold him accountable through Parliament. We have no direct mechanism to ask questions to the Prime Minister. He never anyway gives any press conference. He never comes before the press to give live questions and answers, as Trump does day in and day out, or the British Prime Minister does day in and day out. No. So our only way was either Parliament or judiciary. We brought a petition before the Supreme Court. I myself argued, and I must say that I'm deeply disappointed that the Supreme Court deferred it by saying 2 things. One, that there is no need for a national plan on COVID-19, and that 2019 plan is good enough to handle it. And 2, that PM Care Fund need not be brought back into NDRF. Now, yes, This is the problem, that the judiciary, the Supreme Court particularly, must test the government very, very strictly. And if there is a legislation like the Disaster Management Act, the Supreme Court is bound to give it. After all, it's a welfare legislation. It is a social legislation for the benefit of citizens. Now, that kind of a legislation must be given a meaningful interpretation, an interpretation which will further the protection to the citizens, not an interpretation which really, takes away from the citizens their right. More important than that is that this kind of an approach by the Supreme Court kills transparency. We need in this country transparency. I mean, however responsible, however honest, however popular the Prime Minister may be, he is accountable to us, the citizens, and he must become transparent. He must therefore override his advisors who have advised him to create this kind of a fund. And he must voluntarily tell the country that I have instructed that this fund will be merged with the NDRF and it will be used as per that act, the Disaster Management Act. It will not be used at the whims and caprice of the trustees. Now, this is something which we really, this is a time when judiciary should have sprung up and extended helping hand to the citizens. This is very important. Because, how do you really maintain the balance between the executive arbitrariness and, the constitutional limitations? Only through judicial approach. Lord Denning, one of the most well-known of the English judges, said in 1949, now just see this, 1949, Lord Denning is giving a lecture which is titled Freedom Under the Law. And he says, and I quote, "No one can suppose that the executive will never be guilty of the sins that are common to all of us. You may be sure that they will sometimes do things which they ought not to do, like PM Care Fund, and will not do things that they ought to do. But if and when wrongs are thereby suffered by any of us, what is the remedy?" He asked a question. Then he answers, "Our procedure for securing our personal freedom is efficient. Our procedure for preventing the abuse of power is not." Now, 1949, Lord Denning is warning that our procedure for preventing abuse of power is not existing. In 2020, I must say with deep regret that we also do not have a robust procedure, a robust mechanism, what Constitution envisaged to prevent the abuse of power by the executive. And this is really the biggest challenge that India is facing. And we citizens must really think and introspect on it. In Arthashastra, Kautilya says, "In the happiness of the subjects lies the happiness of the king, and what is beneficial to the subject is his own benefit." Do our political leaders follow this principle? Kautilya's Arthashastra, almost thousands of years old. If the bedrock of our democracy is the rule of law, that means we have to have a fiercely independent judiciary. Judges who can give judgments independent of political winds that are blowing. It should not take color of popular mood, the Supreme Court. It must tell government things which they don't like to hear. PIL is one of the greatest weapons discovered by the Supreme Court itself, yet it failed to use this weapon to help masses against the executive arbitrariness from March 2020. Judiciary could and should have wiped the tears of the people in every which way it could. So with the failure of Parliament, the judiciary to check the executive during last 5 months, governance is at the lowest threshold. Executive is functioning, but not in the right direction. Justice, social, economic, and political, is eluding people. Liberty of thought, expression, belief, faith, and worship is seriously undermined. Fraternity among citizens is missing, as Nizamuddin example shows. depriving them of their dignity and unity of the nation. Frankly, no one knows the real situation that India is in today, be it on personal lives of 130 crore citizens, its economic well-being, its financial strength, or even the situation on border with China. We are just not given information about what is happening on the border. There are all kinds of stories floating around that China has taken away 2,400 square kilometers of our area. Many experts have spoken about it, but our government is singularly silent. And yet, we lost 20 of our brave soldiers in skirmish with the Chinese soldiers. The nation is entitled to know. And this is what all these media channels which every night ask nation what it wants to know really should be asking. Not about Sushant Rajput's suicide, not about the fighter jets coming into the country, but the real issues. And this is a big problem. We are being given information by government which hides more than what it reveals. Sadly, our Supreme Court told us at the beginning of the lockdown to only go by government handouts on state of the nation. This is one of the, I would say, one of the most disturbing decisions of the Supreme Court, where Supreme Court virtually told media that please don't report independently, report what government tells you to report. And in that decision, the Supreme Court, Chief Justice Bobde speaking for the court, told us citizens that we must follow the government's instructions on lockdown, otherwise we will face a prosecution under the law. Thus, we live in state of darkness. Now, this is very important. And I must tell you something very interesting. Today, in one of the most brilliant articles that Pratap Bhanu Mehta has written, the greatest allure of Vishwas is that you maintain by simply believing. Now, we are simply believing what is being fed to us by our government. He says, constitutional social base has dissipated, but with no obvious base to latch on to, the politics of mobilization becomes difficult. Now, this is the real challenge. How do we energize the social mobilization in the country to counter the government? Do we wait till the next election? I have believed for a long time that in India, democracy only functions during elections. Once the elections are over and the government is in seat, democracy comes to an end. Then it's nothing but autocracy. But we are maintaining a stoic silence as a nation while we are in complete darkness. Let us hope wo subah kabhi to aayegi. I am reminded of Sahib Ludhianvi's words, Jine naaz hai Hind par wo kahan hai. This is the real challenge today to India. We need people who love this country in every form, in every which way, and who are willing to test, every action of the government on the constitutional touchstones, on constitutional principles, on constitutional morality, not just accept and just walk away by it. Gurudev Tagore must be wondering from heaven, what happened to that dream that I wrote on independence, where the mind is without fear and head is held high. Into that heaven of freedom, my father, let my country awake. Ladies and gentlemen, let us hope that at least in 2020, our country will awake as Gurudev Tagore had imagined, had dreamt. Thank you very, very much. It's been a privilege. Thank you all for listening to me. It's been an absolute joy to be here on this great platform once again. And I do hope that you will introspect to what I have said. I mean, we all love our country, but we all must ask ourselves question that how can we help our country? Thank you very, very much.
Thank you, Mr. Dushyant. That was a very, very powerful message you gave us and an insight into what's happening there. Like you said at the beginning of your speech, you're going to tell us a lot of unpleasant truths. Reminds me of what Maricha told Ravana, that the person telling an unpleasant truth and the person listening, both are rare personalities. At least we have one side covered. We have you telling us the unpleasant truth. I'm sure the people who need to listen are not listening to this. It's a very, very powerful speech, and I think it'll be early for us to thank you because there are too many questions here. And I will start with one question here. What is your opinion on the lack of alacrity of the courts to look at habeas corpus petitions? How can one hold the judiciary accountable for delaying justice?
Well, we can only hold judiciary accountable by criticizing judiciary as respectfully as we can, but as strongly as we can. Because delays, in hearing habeas corpus petitions is absolutely unforgivable. I argued, for example, for the president of the Jammu and Kashmir Bar Association, his habeas corpus in Supreme Court just about 3-4 weeks ago. And I can tell you, his petition before the single judge of the High Court took 3-4 months. His appeal to the division bench of the High Court took 6 months. And before the Supreme Court, to get him released ultimately, and government ultimately fairly conceded that they will not renew the detention, and he was released just a few days before 1 year period was to expire. Took almost 1.5 months in Supreme Court. And there were no grounds at all. He was detained on the basis of the statements made in 2009-2010. So the government knew that the detention was unjustified. But the only way government could succeed was to ensure that the courts don't hear the matter. So I think there is no justification whatsoever. The liberties of citizens is most important, and the Supreme Court and the High Courts are ultimate guardians of these liberties and right to life under Article 921. And if they fail, then I think, we as a nation have failed. There is no other words in my, vocabulary.
Would it be right to say that the primary role of the Supreme Court is to protect individual rights of citizens?
See, this is very interesting. Article 32 of the Constitution is right to move the Supreme Court for enforcement of fundamental right, which is given to citizens. It is a fundamental right itself. Right to move Supreme Court itself is a fundamental right. But Dr. Ambedkar was asked at the end of the Constituent Assembly debates as to which provision of the Constitution, according to you, is most important. And he said that if I had to put my finger on one article, which to my mind is heart and soul of the Constitution, it is Article 32 of the Constitution. Therefore, the duty of the Supreme Court, and I must tell you that today's Supreme Court has forgotten this completely. When habeas corpus petitions are filed in the Supreme Court today, it says go to the High Court. It's unheard of. It is unacceptable, and it is deeply saddening. So it has a constitutional obligation. It's not just a duty. It's an obligation on the Supreme Court. Citizen has a right to demand the Supreme Court to intervene, and failure of the Supreme Court to intervene, is unpardonable. I can only say that.
So there's a question on the Fourth Estate. Is the Fourth Estate deserving of being a self-governed arm of the society any longer? Shouldn't it be a codified arm like the three pillars of democracy?
There is no doubt that the Fourth Estate, the media in this country, at least the section of it, has behaved extremely irresponsibly. And it has, as a result, we are seeing today, take for example this Nizamuddin Markaz case. Can you imagine that these people who have come, for their teachings are, and they were there with the permission of the government. The central government had given permission, the state government had given the permission. You suddenly declare a lockdown of, 6 hours. Trains, buses and planes are not functioning. And how do you expect these foreigners to go back? And then you say that they are spreading COVID-19. Media started virtually saying that they were human bombs moving about. Now, is this the kind of a treatment that we give to our citizens? Is this how we criminalize a sickness instead of sympathizing with them? And this media, nothing is happening. In fact, tomorrow only we are arguing a petition in Supreme Court. And, it's really, I would say it's an extraordinary situation where media, at least a section of it, can get away saying anything and everything, inflame passions amongst people, create discordant ties between the communities. It's very easy to inflame the passions amongst the minority and the majority community. And they go. So I think time has come when we must have regulation. We must regulate them, because Press Council of India controls the print media, but has no powers to punish them. And there is no similar body so far as the electronic media is concerned. And government has powers under various statutes. Government never exercises the powers. So it becomes extremely difficult. And mind you, the airwaves are public property. The media is utilizing the airwaves which belong to you and me. You have to therefore have responsibility when you use public property. You can't abuse that right to create this kind of situation.
What you have said today is probably one of the most important things that citizens have to understand, that if they want any redemption from here, it has to be by them to act. They have to know how to talk, how to voice their concerns, how to question the government and not take anything lying down. There have to be 100 conversations like we are having today across the country, asking the government questions, asking the institutions questions. And I think you have done a phenomenal service to the country by asking these very, very important questions. They have not been asked at all in media. They have not been asked by institutions to other institutions. And therefore, this is very important. Really, we are obliged to you. You were talking about COVID and the country's and the government's management of COVID. There are two things here. One is, scientists have said that COVID-19 is probably one of the first pandemics that's going to hit the world, and several others may follow in the next few years. It's therefore important that we handle this with a professional and a scientific approach, which does not seem to be happening. Secondly, government seems to have given up on managing COVID. Where is the leadership? What are they talking us? What are they doing? We don't see anything happening there. It's just they have left it to us, whether it is the state governments or the central governments. The leadership is completely absent from telling us what's happening or what needs to be done. How do you react?
Well, before I answer that, let me tell you that we as citizens are also acting irresponsibly. We need discipline and we need to follow the rules and regulations. So if it is necessary, as scientists tell us that we must wear masks in public places, we must do that. We must avoid getting social contacts unnecessarily. We must not have social contacts. So there is tremendous responsibility on us citizens also. See, government alone cannot do anything. It is we the citizens. But the difficulty is that citizens are not being guided properly. And unless and until citizens are guided, that's why I said that you have to have a comprehensive national plan where you have do's and don'ts in a situation like this. And that plan, once in place, the citizens can understand. Today, every municipality, every government, every district magistrate is issuing his own directives. It is impossible for us to follow. One day you say that there'll be a closure of this bazaar. Next day you say it will open. So, people just don't know what is happening. I feel that there is no doubt that government has not acted in a planned manner. Take any other country. Take, for example, England. The Prime Minister is standing on every press interview with top medical experts. In South Korea, the Prime Minister or the President gave the entire power to the 3 epidemiologists and said, you please tell us what we should do as a nation. And you decide the entire policy. We have seen that in India, heart specialists are talking about this virus on the television channels. We have seen that government is consulting these kind of experts who are not experts in epidemiology. Now, and government is virtually not even consulting them. Government is acting on its own. The bureaucrats can't do that. The ministers can't do that. We needed to, I said on 24th of March in one of my articles, that government needs to constitute a core group of people. See, this country has the best talent. The people have amazing capacity. There are outstanding minds. Why is it that you see any institution in the world today on television and the top experts are Indians? Now, we needed to create this kind of a core group, and this core group should have driven the entire management of fighting COVID-19, both in terms of health issues, in terms of economic issues, in terms of social issues. In every which way, the core group should have driven the government's policies, which is not happening. So, I mean, we are bound to be where we are, with cases, almost 70,000 cases being registered every day. So and people are, I mean, we could have avoided deaths of people, the suffering of the people. We have a duty. We can't just, say that, oh, COVID has come and therefore throw our hands in despair. No. We must marshal every available human resource and material resource at our command to fight this. Unless we do that, we can't fight this battle. And you are right, government seems to have given up.
No, sir, but then there's a good question here. At a personal level, how much of a struggle it is for you personally, or any advocate now practicing in the courts, between constitutional obligations, ethics, your own satisfaction, and from what we can hear, your high level of frustration on what's happening?
Well, I won't say I'm frustrated, but I am definitely deeply disappointed, and I'm sad from within. I began practicing in 1978 when judiciary was absolutely, fantastic. I started practicing the Gujarat High Court, and in those days we had, I think, 18 judges. And I can tell you each one was better than the other. And it was amazing to see the kind of personal character, their demeanor, their knowledge, their courtesy, their own, behavior. They were absolutely unbelievable lot of, Indians at that point of time. Slowly and steadily, we have really lost out that kind of a judiciary. And the biggest damage has been done by the judges themselves in 1991-92, when they decided the judges appointment case and wrested the power from the government to appoint judges in high courts and Supreme Court. And it is, these appointments, I can definitely tell you one thing, are far from satisfactory. The judgment had said, Justice Verma speaking for the court said, that best amongst those available should be brought to the higher judiciary. And what we find is that more often than not, the appointments in high courts are made on purely political considerations, and elevations to the Supreme Court or Chief Justices of High Court are being made purely on seniority, which is not what was desired. You need, this higher judiciary needs outstanding people, and we have outstanding lawyers in this country. Believe you me, they are world class. And if given a chance, we can transform the judiciary overnight. See, this backlog of cases, for example, justice delayed, justice denied, is something judges have to understand. Now, as a result of this, the economic growth cannot take place. Which foreigner will invest $1 billion in this country if he knows that his investment is not secure? Because if it goes into litigation, he will be facing 25 years of, battle in the courts in India. Now, you have to therefore create infrastructure. You have to have, human resource, which is clearly, aimed at giving justice as quickly as possible. No, I have no frustration, but yes, these are trying times. One does feel extremely disappointed and sad. I have had many sleepless nights in recent past, but then one has to go on. What can one do about it?
Yeah, that's true, sir.
You talked of a problem like COVID-19 being handled by experts. But if you see the last 6 years, all major decisions have been taken without professional expertise backing it. Demonetization. Even today, after 4 years, we complete 4 years this November. We have no idea why demonetization was announced, what was the thought behind it, real thought behind it, who recommended it, and who was the expert who was backing it. The same thing is happening with COVID response. We have no clue who's doing it. Is it some bureaucrats running it, or is it some ministers running it?
That's true. I mean, demonetization may have had an object of fighting black money, but the government should have realized that in this country it is well nigh impossible to fight, parallel economy. In fact, parallel economy subserved India's interests. I don't agree to that at all, and I must say that I'm I'm one of the few people in my profession also who has never taken cash, as fees in my 42 years of practice. And I have been given rewards as one of the highest taxpayers by the income tax authorities again and again. But people have their own reasons. I mean, you can't change the character. See, there is no doubt that post Jawaharlal Nehru, and especially after Mrs. Gandhi came into power, the erosion of values in the country, our materialistic approach and our loss of character has happened at such fast pace that it is impossible now to bring it back to what it was. It was very different in those days. So I feel that it was a good measure, demonetization, but we all know, and government has not even told us officially, that they got actually more money into banks than what was supposed to be in circulation. Therefore, the whole object of that exercise was completely defeated. And we know that all across the country, large number of politicians and bureaucrats and police officers had, deposited their monies into various banks to, whitewash it. So far from achieving the object, it really became a platform to whitewash black money into white. And so it was a thoughtless measure. There is no doubt about it. And time has proved it. And the scars inflicted by it are very serious.
The question, I think, is in the context of Kashmir maybe, but then the question says, in case of conflict between liberty and integrity of the nation, how do courts balance these conflicting interests? And are these interests conflicting, liberty and integrity of the nation?
See, you can always balance them. No, I would always say that you have to balance both liberty and national interest. Nobody for a moment can suggest that national interest or national integrity or national sovereignty must be sacrificed. Certainly not. And if you find in a given case that a particular person is not desirable, provided you have sufficient material to say so, not the ipsy of a constable. In fact, I'll tell you something shocking, that during the Constituent Assembly debate, this was discussed, Public Safety Act, and late Kanhaiya Munshi, one of the greatest Indians to be ever born. Kanhaiya Munshi was an amazing human being. He was a freedom fighter. He was a top lawyer. He was a great author, and he's written the finest of the books in Gujarati literature. And he was an educationist. Bharatiya Vidya Bhavan was set by him. Kanhaiya Munshi said that Public Safety Act detentions are done by Superintendent of Police on a recommendation of a constable. He signs it without verifying anything. This is in 1949, he says that. The situation is not different today. Yes, the balance must be struck. The integrity of the nation must be protected. I will be the last person to say that we should be soft on terrorism. We have to be strong on terrorism, but we must know how to identify terrorists. We cannot demonize a community as terrorists. And this is something which is very important for us to remember, that, and this is what Ambedkar had said, for example, he said that we are being attacked for the provision for minorities that we have made in the Constitution. And he said that if we have done it because those Muslims who wanted to leave and go to Pakistan have left us. But those who had a choice and did not leave have decided to stay here and put their fate in the hands of the majority. And it is therefore for the majority to make them feel at home, make them, weave them into the national, mainstream of life. And Sardar Patel himself and Shyama Prasad Mukherjee all have echoed this sentiment during Constituent Assembly debates. Unfortunately, the ignorant nation doesn't know about it. People are not willing to talk. The politicians mislead us, saying Sardar Patel this, Sardar Patel that. But Sardar was one of the most secular leaders, tallest leader of this country. And he said that we as majority have a duty to protect the minorities. Ambedkar says they are an explosive force if they are not brought into the mainstream of the society. And today, we have to be, we can't ignore hard realities. Thousands of suicide bombings have taken place in Islamic world. Only one in India, Pulwama. That shows that the minority community has placed its faith in the Constitution of India, in the majority population of India. We have to take them as, we cannot demonize them, and we cannot, start doing what what we did in Nizamuddin Markaz incident.
Yes, sir. Now we come to this, there's a question here on this vexing issue of contempt. Can we have your opinion on this, and where will this case go, and how will it change the place for public criticism of judges' conduct and their judgments also?
Well, I would definitely say that the law of contempt is an antiquated law. And except, the civil contempt is absolutely necessary, because we are talking about criminal contempt. It's very difficult to balance between the fundamental freedom of speech and expression and, the court's approach in treating it as a contempt of the court. Frankly, the judges must realize one thing, and which was said by, I think, Chief Justice Mukherjee in 1953, that judges have to earn respect. They cannot demand respect. And what they are doing by enforcing contempt law is demanding respect. So nobody will criticize judges if judges, by their judgments, by their personal conduct, really win the hearts of the people. No, but there is no need to. I have been a lawyer for 42 years. I love my judiciary. I love my judges. But that does not stop me from criticizing them time and again, because I want my system to improve. I want it to be better and better. And it can be much better. The reason why it is not changing, it is not improving, is because, with greatest respect to the judges, they live in ivory towers. They don't want to listen to criticism. They don't want ideas. They want to decide amongst themselves what is good for the institution. They have no idea that what they are doing is not good for the institution. And they just don't want to see the mirror. So it is our duty as citizens to show them the mirror. And I don't think that a singular judgment in Prashant Bhushan's case should deter the citizens from showing that mirror to the judges as and when it is needed. Of course, I must say it must be done with respect, and it should not be personalized.
Is there a practical way in which one can ensure that judges are not swayed by postings and appointments that they get post-retirement? Could it be done only by law, or is there another way to do it?
I'll just give, Vicky, I'll give you.
Sure.
Just that folder. I'll give you a very beautiful answer.
Okay.
That one of the things that I love about is the Constituent Assembly debates. And I read them again and again and again and again. And what you are saying was discussed in the Constituent Assembly by K.T. Shah, another, great freedom fighter, a great Gujarati, leader. And this is on 10th of December, 1948. Separation of judiciary from the executive is one of the directive principles under our constitution. And it was being debated. And this is what he says. He says He says, I would say that so long as you have not merely combination of judiciary and the executive, but also the possibility of translation from a high judicial office to an equally high or sonorous executive office, Rajya Sabha, so long would your judiciary be open to suspicion. So long your administration of justice would suffer by personal privileges or personal ambitions. And so long, therefore, you will not be able to maintain your civil liberties to the degree and in the manner of purity that is highly desirable in a country like this. Now, this is 1948. And I don't think, very few judges would have read these warnings that were expressed by judges, by our forefathers again and again. Judges becoming governors, becoming, Rajya Sabha members. It's been going on for a long time. It's not today. It has happened, or contesting, election as speaker or vice president or president. All that is really bad for judiciary. To my mind, we should bring a legislation which prohibits judges from accepting anything, including arbitrations post-retirement. We must give them salary, full salary throughout their life, not pension. But we must have fiercely independent. Any kind of temptation is bound to be bad for judges. And judges do get tempted. I have seen it in myriad forms.
I will ask one question before Vikram closes it. Someone has asked this question, that it is reported that PSUs have contributed, semi-government bodies have contributed, and municipal corporations have contributed to the PM CARE Fund. Is this not a good reason why it should come under public scrutiny and CAG purview?
Absolutely. You see, one of the bases of declaring a body as a state within the meaning of Article 12 of the Constitution is its composition, where its funds comes, who is managing it. Now, on all counts, this is a state. And if it is a state within the meaning of the Constitution, it's subject to writ jurisdiction of the courts. And it must therefore be treated as a public body and not as a private trust. Undoubtedly, thousands of crores have come from public funds.
Yeah.
And therefore, there is no reason. And I am really deeply disappointed that the Supreme Court took the view that it did, saying that it is a private trust. The government is rightly attacking the Rajiv Gandhi Foundation for the same grounds. All kinds of inquiries are ordered against it. Then why not against the PM CARE Fund? So government can't have, they must speak in same voice.
I know. Sir, this fund was constituted sometime in March 27th. And as practicing chartered accountants, me and Ajay will know that to get a Section 12A permission and an ATG normally takes at least a year. They've got it in a day. And I'm sure they've got it in a day because somewhere at some level government was interested in that. The government.
Not only that, but its contributions are 100% income tax free. One. And two, the companies have been allowed from the CSR to contribute to it.
Correct, sir.
Which clearly really adds up to all these to say that it is a public body and must be treated as a public body, must function like a public body, and must be audited like a public body.
But the fact that it was all done, executed, just like Article 370 was abrogated, with an amount of confidence that it will not be set aside by the courts. That confidence comes as
I think today's executive is well justified in having that confidence.
Absolutely.
Because right from 2014, take for example Birla Sahara case. I'll tell you.
Yeah.
There, this and both of you understand chartered accountants, and I'm sure all the listeners know that when you have maintained certain books of accounts in the course of your business, even if they are unofficial, they are admissible in evidence. And under the Income Tax Act, they are admissible, nobody can question them. Now, these books of accounts maintained by Birla Group and Sahara Group had full detailed accounts. I have seen those books, full detailed accounts of payments of money in bribe forms to every conceivable politician from across every conceivable political party in India. And yet, because it had the names of the Prime Minister himself, yet the Supreme Court says that you cannot raise voice against constitutional functionaries. You cannot rely on these kind of documents. Every day, ED, CBI, and all authorities are harassing citizens on the basis of such documents, arresting them, sending them to jails. But when it comes to politicians, the Supreme Court says, no, 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 don't, this is all inadmissible. So it is, I mean, I must say that the court has really been extraordinarily liberal to the executive since 2014. And that is why I admire that, I mean, not that Congress was free from corruption charges, but at least the Supreme Court gave important decisions in 2G and Colgate cases during Congress time and set aside those licenses which were given, because the Supreme Court found that, yes, they were given on collateral considerations. So, I mean, that happened since 2014, not a single decision. In fact, you know, the way Rafale matter was handled by then Chief Justice Gogoi was, I would say, extraordinarily disturbing. You know, these sealed cover packages, you know, this kind of orders, abrupt hearings, and totally unsatisfactory. Totally unsatisfactory. They just did not want to go into it. They did the charade of going into it and, you know, decided and gave a complete clean chit. And now we see what is happening. The offset partner of the government was none other than Mr. Anil Ambani. And today he has a debt of more than 2 lakh crore and he can't pay a penny. And the government is singularly silent about it. You have seen recently CAG has refused to even go into the offset contract. So it's very, very, I would say, there is a great responsibility on the shoulders of the Supreme Court. And I really hope and pray, genuinely pray, that Supreme Court really comes back into its real spirit and it starts testing. Nobody says you set aside everything that government does, but you must test it on the touchstone of the constitutional spirit.
One last question. There are 31 judges in the Supreme Court. Why is everyone silent? Or is everyone a party to the same approach to the judiciary?
I won't answer that. I would only say Supreme Court as an institution needs to really be, I would say, performing its duty, constitutional duty, because the very basis of theory of checks and balances is, as Ambedkar said, that it will result in tyranny and chaos. So if judiciary allows executive to do whatever it wants to do without testing it on the, you see, one thing we must understand, if Ambedkar said Article 32 was very important, I would say Article 14 of the Constitution is its heart and soul too. Yeah. And Article 14, you know, prohibits any kind of arbitrariness on the part of the government. Now, every action, therefore, you know, one thing is very interesting. Supreme Court has itself said that there is nothing like an unreviewable decision in our constitutional framework. Now, if every decision is reviewable, and if these decisions, these actions of the government fail on touchstone of Article 14 as they do on the face of it, I mean, demonetization, 6 hours lockdown, the Supreme Court must come down heavily on the executive. The reason is that you are not only, you know, taking, telling the government of the day that what you have done is wrong, but you are telling the governments in posterity that we will not tolerate this kind of abuse of power. Now that message must go from the Supreme Court. And I do hope and pray, and I really wish that citizens would get up and beg the Supreme Court, pray to the Supreme Court that that message should start going sooner than later.
I think, sir, on that note, we will close this. There's a comment here which says that we hope that the Supreme Court judges will wake up and perform their duties on truth, at least from onwards, and that God is watching their activities. I don't think we should go to that level to find out whether God is watching or not. But we are thankful to you, sir, for bringing
I can
unpleasant
only say one thing, that God may not be, but the Constitution of India is certainly watching all of us, including the Supreme Court.
Yes. Yes, sir. 100% right. That I was going to say that. I think that when you refer to the passages in the discussion, the Constituent Assembly, a simple constitutionalism, I think, will solve many of the ills of the Supreme Court. Maybe they should attend a small training course in the debates of the Constituent Assembly.
At least they must read the Constituent Assembly debates in great detail and apply it in letter and spirit. I have great hopes from the court. So let us pray that something comes out. Thank you very, very much.
Thank you so much, sir.
Thank you very much. Thank you very much.
Thank you so much, and thanks for everything.